your own insurance company that you've been paying is
you're
now
right.
telling you, yeah, no, we don't want to do what's in our policy.
Right.
In order to get paid, we're going to put you through this process of going through arbitration.
Doesn't feel very neighborly. Hello everybody and welcome back to another episode of The Airing of Grievances. I'm Eric Reamer. That's Robert Grieve, and we are ever thankful that you are here. If this is your first time with us, we'd like to say a warm welcome, and if you see what you like, would you please give a thumbs up? That helps YouTube know that this is a good video to share with other people, and we appreciate that very, very much. And of course, if you're family, you know, we love you very much, and we're grateful for your being here. Now, Rob, happy Saturday to you.
To you, my dear friend. Happy Saturday.
Absolutely. All right, so those folks over at Repair Driven News are doing a fantastic job, and they
damn day.
They knock it out of the park every day, and we are so grateful for them. Dave LaChance put out an article recently talking about a settlement that the largest insurance company in America,
Property and Casualty,
yes, thank you, settled for $650,000. The headline reads, State Farm pays $650,000 to settle a bad faith lawsuit. And of course that caught my attention, so I thought I'd bring it to Rob. Rob, you've got some thoughts that go along with this as well.
This article is rich with nuggets, and we've been talking a lot about insurance companies making it harder and harder on the consumers to get paid properly, and to it should be a hassle-free experience from that side of the fence.
You sign a contract that says if this happens,
this is what happens.
They will take care of you.
Yeah.
Right? Not so much.
Yeah. Well, if there's a way to get out of it, they're getting more and more creative, as this article shows. So the first line says State Farm paid $650,000 to settle a lawsuit accusing it of acting in bad faith against two of its own customers by refusing to pay an arbitrated award, according to the attorney for the plaintiffs.
So it's already gone to arbitration, which is a step down from court. Yeah.
You have a lot of rights within your policy. Generally speaking, you don't have necessarily all the rights in every policy.
Sure.
So
this is a good time to remind our friends, check your policies.
Yeah. In a lot of states, State Farm does not have the Appraisal Clause, which we've done a video on, the Appraisal Clause.
Yep.
Which is a consumer protection, where they don't have it for vehicles that are going to be repaired. They have it for total losses.
Okay.
And the Appraisal Clause basically says if you and us don't agree, we can each get our own appraiser, let them fight it out, goes to an umpire, and decision's binding on all parties.
Got it.
And they don't have that for a repairable vehicle. They only have that if you don't agree on the value for the total loss that they're offering you.
I understand.
And it's important to have it for a repairable vehicle too. Otherwise, they just, whatever they want to pay, that's what they pay, and you don't have any way to argue it without actually going to a full-blown suit. So that's not a good place to be.
Right.
But in this particular case, we're talking about personal injury.
Yep.
Where the people were hurt, and these people were badly injured in a crash when their vehicle struck a vehicle that was stopped sideways in the traffic lane. The driver of the other vehicle was uninsured.
Everyone's nightmare.
Yes. So I want to talk about uninsured for a second. Your policy should have the most robust uninsured, underinsured for both personal injury and property damage. So what the uninsured, underinsured does is if somebody causes you harm that is not your fault and is their fault, but they don't have coverage to make you whole, it could be an underinsured, like they don't have enough coverage,
Right.
or they may not have coverage at all. But at that point, you want to use your under and uninsured motorist coverage,
Right.
not your own coverages, like your comp and collision and
Right.
all the rest of that. And there's a lot of reasons for that. But in this particular case, they had uninsured for personal injury, and they had limits in the contract, $250,000 up to $250,000 per person. There were two people.
Yep.
$500,000 max.
Okay.
So, with a limit of liability of $1 million. So, it seems pretty cut and dry. There's the contract.
That's
You know,
it.
You bought the contract, you pay for the contract. There's the contract. The contract has what's going to happen.
Right.
And State Farm decided that,
They didn't like it.
yeah, they didn't like
They
it.
didn't like the terms, even though the terms that they wrote.
Yeah, so, and you'll find all that information on your declarations page. So if you open up your auto policy, it's going to give you all your coverages, and you want to see underinsured, uninsured, and you want to see it for property damage and personal injury.
Okay.
And you want to make sure you have the right amounts, because today's cars are very expensive to fix, and so on and so forth.
And not to mention
And
hospitals.
hospital bills.
Yeah,
You can't
really
get away
expensive.
from them. So, in their complaint, the Cooks said that they made several efforts to settle their claim, which State Farm responded to by demanding that the claims proceed to arbitration before a 3-judge panel. So, your own insurance company that you've been paying
Oh,
is
you're
now
right.
telling you, yeah, no, we don't want to do what's in our policy.
Right.
In order to get paid, we're going to put you through this process of going through arbitration.
Doesn't feel very neighborly.
No, and that a 3-panel arbitration is you hire an arbiter, they hire an arbiter, and then there's an independent umpire, basically,
Right.
arbiter. So that's the 3-panel. And the 3-panel unanimously entered an award of $100,000 to Charles Cook and $400,000 to Bernadette Cook. It's over, right?
Should be.
It's over. Instead, State Farm refused to pay, citing an obscure Illinois statute that it said allowed it to refuse to pay awards more than $75,000, even though the awards were within the limits of the Cook's policy.
That almost bears saying again. State Farm lost the arbitration, and the judges said pay $500,000, $100,000 to the gentleman, $400,000 to the woman, and State Farm says, no, you know what? We remember reading a law on the books in Illinois that says, if it goes beyond $75,000, we're just not gonna pay any more than that.
Yeah. So they have a contractual amount in their policy.
Yep.
And just to give an example of that, if you had a homeowner's policy with them, and you had $1 million on the dwelling,
Yeah.
and you had a total loss, fire or whatever happened
God
to
forbid.
it, and they come back and say, yeah, we're only going to pay $250,000.
What?
Yeah. Well, wait a second. but it costs $1 million.
I paid
Yeah.
all my life for this moment.
So they refuse to pay it. It's interesting. They have a contractual amount in there, and when you look at your deck page, you're going to see how much of your premium goes to each coverage.
Sure.
Okay, so your collision, your comp, your glass,
Yep.
all the rest of that, your liabilities, your underinsured, all the rest of that. There's a dollar amount attached to each one of those, which is what, when you add them all up, that's your
Premium.
annual or semi-annual premium. It leads me to think that maybe they're charging you for something that they never intended to pay in Illinois. Because they know of this little statute, because the lawyer that was representing these people never heard of this statute before. So rejecting the award and invoking the state law, Dixon said, indicates that State Farm does not trust arbitration. The very same arbitration that they made these people go through.
Yeah, it's in the policy.
Yeah. A process it routinely uses to settle insured's claims. Routinely uses to settle insured's claims. So routinely they are making people go through this process in order to pay the claim?
Again, not very
If I was reading this about any insurance company, I would be, time out.
Right.
If they are routinely putting people through the arbitration, then I paid my premiums. I have a contract. What is the problem? Why do I have to? And when you have to get lawyers involved and they aren't doing their end of it, it can turn quickly into a bad faith claim. And bad faith claims are where the attorneys get to make money and you get to be made whole, and there's a lot that goes into all this stuff. But they've been doing this for 3 years.
This family
trying to get this thing settled.
Yeah.
And in the end, Dixon said the settlement, which incorporates the initial claims, is believed to be the largest reported for a bad faith claim against State Farm in Illinois. The dollar amount speaks volumes as to the conduct of the insurance company.
Yeah, they were in trouble.
Yeah. Bernadette Cook, speaking through Dixon's office, the attorney, it was bad enough that we were both seriously injured in the crash. But the way our own insurance company treated us just made it so much worse. Who you get insurance through is really, really important.
Yep.
And if you're hit by somebody else, it's deemed to be their fault. And let's talk about a 3-car pileup.
Okay.
Somebody in the rear hits somebody in front of them, hits the person in front of them. The person in the rear is responsible.
Sure.
And that's usually a clear situation. But if to fix the 2 vehicles that it hit, some policies have a $15,000 max that they're going to pay, then there's probably not going to be enough money in the policy to pay for the repairs. That insurance company is going to tell you, go back to your own insurance company, because there's a limits issue. Limits a liability issue.
Right.
When you go back to your own insurance company, many times the insurer is going to want to put it under your collision. We're talking about property damage now.
Okay.
Your vehicle. They'll want you to use your collision. Well, your collision deductible may be different than the deductible on the underinsured, uninsured.
Okay.
So if they want you to do that, you want to ask why. And why is this not going to go under my uninsured or underinsured part of my policy?
Which is why we got here in the first place.
Right. Because when it goes under your uninsured, underinsured part of your policy, then that insurance company is not working under your contract. They're working as if they were the insurance company that was the one that hit you at fault. And opens up a whole bunch of different rights that you would have against that person. So there's a lot of reasons why they're going to want to jam you into using your own collision coverage. The other thing is, if you use your own collision coverage, then that gives them the ability to ding you and raise your rates. If it's underinsured there wasn't enough coverage, or uninsured, there was no coverage, have your insurance company put it in writing as to why they are not using that as the first line of defense in your policy. So that's what we have today. This is an important subject for so many different reasons. But insurance companies are increasingly badgering their own consumers.
That's
the letters that we get, and it's unbelievable.
I'm reminded of the video that we made. I think we actually made two, talking about the 84-year-old woman.
Yep.
Who was also, virtually, literally bullied about her policy and the limits thereof. And again, it goes back to knowing your policy. We are in a society today, Rob, where all the marketing is save 15%, right? Or, we're the least expensive, we'll find you extra money, whatever. But it's all to get your premium down to a minimum, which takes your coverage down to a minimum. And if you really look at it, maybe just a couple of extra dollars per month gets you coverage that will actually cover you, at least if your insurance company is ethical and filled with integrity.
Well, I just received a phone call yesterday on my cell, and it was a local number, so I answered, even though I didn't recognize it.
Yeah.
And it was an insurance company saying, "Hey, we sent you out a proposal. We want to just talk to you about that," which they did not send me out a proposal. That was a lie, and I would never go with that company.
Yeah.
And they said, "Well, how they want to keep you on the phone talking." And we just want to save you money. I said, I don't care about saving money. I care about having the right coverage at the right rates. And I already have that. I would never dream of going with your company. And it's unbelievable.
Some of you watching this right now probably would benefit from having that kind of conversation with your existing insurance company. Because we're talking about State Farm today, which again is the largest property and casualty in the U.S. But there's a lot of insurance companies who, when you need them the most, cut the corners to benefit their bottom line instead of taking care of you.
Oh, and just to make matters a little worse, I'm going to leave you with this last sentence.
Yeah.
The complaint also alleges that during the arbitration process, State Farm's lawyer brought up personal information about one of the plaintiffs that the carrier had been barred from presenting as evidence. This suit referred to that behavior as willful and wanton conduct.
Misconduct,
Yeah.
Yeah.
So they're going to go after you pay your premiums.
They'll raise the dirt, and they'll make it part of the public record if they're able. In this case, fortunately, the judges barred that.
Yeah.
But, wow. All right. Well, Rob.
Happy Saturday to you.
And to you.
Our dear friends, happy Saturday to you. I hope you have an amazing week.
Yeah.
Peace.